Good evening, everyone. Thanks for joining us for the monthly labor law update for the month of November 2022. Um, in this month, starting with the amendments, there have not much new amendments that have come in during this month, except that the Kerala government has made certain changes to its rules under the Kerala Child Labor Prohibition Regulation rules, where they have reduced it to say that if a child is employed or engaged for a family enterprise, as far as it doesn't affect the studies and education, it's fine. And if you're to use a child as an artist in any kind of audio or visual media commercial events, then the district labor officer should be informed about it, including the income that's being generated. And they also have a fund to take care of children and adolescents who are affected and if they're engaged beyond these rules. So that fund amounts how to be utilized, these things which have been now amended by the government in these rules. The Ministry of Skill Development, which takes care of the apprenticeship rules, has also brought in some changes. But however, there are not any significant changes that would come about. It's only about the rate of stipend to be paid by the employer that would be prescribed, and what cost of it would be borne out by the central government. The provisions of the ESA Act has been extended to the district of Dindigul. So the entire district of Dindigul is now covered under the provisions of the ESA Act. Any establishment in this region would need to be covered under the ESA Act. Similarly, Similarly, under the ESA Act, for in Orissa as well, 3 districts have been brought within the purview of the ESA Act with effect from 1/12/22. The ESA Corporation has also extended medical benefits under the Tamil Nadu employees insurance rules to Chengalpat, Karur, and Salem districts in Tamil Nadu. Moving on to our next segment, the quiz segment. The query here is under the IR code, who would be considered as a worker? Person in managerial work, a supervisor on salary of 15,000, a supervisor drawing wages above 18,000. In our across the globe segment, we today look at the laws that are undergoing change in UK and Australia. In the United Kingdom, non-compete clauses are permitted, legally recognized. If you look at India, you cannot have a clause in restraint of an employee taking employment with a competitor. So if you're having a person who's in your employment, you cannot sign an agreement with him saying that he will not join a competitor. That's not permissible in India. Whereas in United Kingdom, the same is permissible. You would be permitted to sign such clauses in respect of certain kinds of employees. Now that kind of employees who can sign is being restricted. So the low-income workers, or what they call it also 0-hour workers, these persons, you cannot sign such a clause. And these are not enforceable in respect of such employees. So it's only a very limited group, maybe somebody like in the research and development, where sensitive information, or in your finance, where some sensitive information goes in, where such kind of persons alone, you could have a restricted clause providing that they cannot be taking up employment with a competitor. The Australian government has introduced a new paid leave. Across the globe, if you look at, paid leave is not given in many countries, but this is a paid leave, and this leave is for family and domestic violence, and it is even for children age 16 or above, if they're employed, even they are entitled to this leave. It's something very unique where they do try to recognize that there could be domestic violence. Maybe we tend to feel that it's only in our country that we tend to hear more about domestic violence. Apparently, this proves that it's there even in other developed countries. And recognizing that, the Australian government here has provided for 10 days of paid leave for family and domestic violence as part of the national employment standards. Somewhere, would we also be aping a similar leave? Or would it be suitable for our conditions is something that has to be debated. In this month, in the Knowledge Corner, we are looking at limitation, delay, and latches under labor enactments. It's a very wide topic. We may not be able to do justice in the short time that we have. First and foremost, what we mean by delay, a limitation is there is a specific clause in the statute itself, providing that this is the days or years within which you need to approach the court or the forum. But even cases where the statute doesn't provide, doesn't mean that the employee or employer, whoever it is, cannot, at their whims and fancies, approach the forum at any point of time. So that is delay and latches. That's the difference between your limitation and delay and latches. So when we look at it, labor legislations, some of them provide for limitations and many don't provide for limitation. So first, under the ID Act, if you look at a dispute under Section 2K, there is no limitation, but delay and latches applies to it. So a union can raise an industrial dispute even if it's 5 years later or 6 years later, and courts have held as far as it's a valid dispute, it could be referred. But from 2010 onwards, in respect of an individual dispute, a 3-year limitation period has been brought in. The court seeks to reduce it even further down to 1 year. So within 3 years, the workman has to approach the labor court or tribunal, challenging his retrenchment and termination. When it comes to petitions under 33, it could be an approval or permission petition. They need to be filed on the very same day. So there is a very strict limitation in respect of applications under Section 33. Computation petitions under Section 33C, there's no limitation. Courts say because it's an accrued right, the employee can approach the court at any point for computation of his monetary relief. Moving on to Factories Act, these are again more procedural. What is more needs to be seen is the prosecution. So once an inspector or anybody from the dish were to inspect, within 3 months, they should file the case before the concerned magistrate court. So that 3 months limitation is quite crucial under the Factories Act. Under the Provident Fund Act, for initiation of Section 7A, there is no limitation. So the authorities can initiate a Section 7 capital A proceedings at any point of time. But if an employer is set ex parte, then the employer can file an application within 3 months to have the ex parte proceedings set aside. There is a power also to review an order. So even if you have participated in a 7A proceedings and an order is passed, you can seek review of it within 45 days. Or you can file an appeal to the tribunal within 60 days. And the delay of further 60 days can be controlled by the tribunal. So maximum is 120 days. So if a 7A order is passed, within 120 days, you need to approach the tribunal. And any order of the tribunal, you can seek a modification amendment within 5 years. Similar under Gratuity Act, what is more akin is these are all again, there's no strict rule of limitation. When the employee is to approach, there is always the delay is condoned. So if you look at an employee approaching under Section 10 to the controlling authority, the delay can be condoned even if it is beyond 90 days, and they tend to condone the delay. The last is an appeal. There is no provision to condone. So if the controlling authority under the Gratuity Act were to pass an order saying that the employer is due to pay so much gratuity, employer is required to challenge that order within 120 days maximum. So 60 days to challenge it and 60 days to condone. So maximum is 120. If you file an appeal on 121st day, it would not be admissible. Under the ESA Act, again, if a 45A order is passed, you have 3 years to file an appeal. But of course, the ESA court also has the power to condone delay beyond that. And against the order of the ESA court, you can approach the High Court within 60 days. And again, the High Court has the power to condone if it's beyond that. Minimum Wages Act, these are all recommendatory under the code. That's why I'm not going into that. But if minimum wages, if you see within 6 months, they need to file an application. But again, these can be condoned. The high courts have held up to 3 years can be condoned. So if there is a claim for minimum wages, it doesn't mean it has to be filed within 6 months, even if it's filed after 6 months, but within a reasonable time, courts tend to condone the delay. I'll move on to the Shops Act, where if you're to file an appeal against a termination, the employee has to file 30 days. But again, this limitation can be condoned by the authority under the Shops Act. Moving on now to Know Your Codes. As per the OSH code, no worker in a factory, if he's already worked in a similar establishment within preceding 12 hours, he can't be allowed. So double employment is prohibited under the OSH code. It's also there under the Factories Act, existing Factories Act. The same has been replicated under the OSH code. Apart from it, when it comes to bonus, the employer is required to credit it within 18 months to the bank account of the employee. That's how the Code on Wages provides for. So bonus is concerned, it has to be credited to the bank account within 8 months from the close of the accounting year. The government pensioners, there is a deadline by when they should be, the life certificate should be given by the pensioners. That timeline is to expire on 30th November. So every pensioner is required. This is not under the Provident Fund Act, but under government pension scheme. Yeah, every pensioner is required to give. The case law panel, we are looking at 2 judgments. The first one of the Supreme Court. This is more to do, of course, with public employment, not with private. But it could also be applicable to private sector as well. The concerned person here was recruited on a contractual basis, pending a tender. So the Zilla Parishad was calling for tenders for certain services, but there were some challenges to the tender. Till that time, they wanted somebody, and therefore they had recruited the petitioner or the workman concerned. Then after the tender was called for, tender was finalized, his services were terminated. The High Court directed that he had worked for nearly 9 years on a contractual basis, and therefore he should be made permanent. The Supreme Court quashed the order of the High Court and held that you cannot direct such regularization of contractual and temporary employees, even if they have worked for many years. This pertains to a question under the Contract Labor Act, whether a dispute can be referred in relationship or contract labor. So the government said that there is no non-existence of employer and employee relationship, and therefore it declined to refer. But it was held that that is something for the labor court or tribunal to adjudicate upon based on the evidence that parties may place, and therefore at the threshold, the government declining to refer is bad, and therefore directed the government to refer the dispute for adjudication to the tribunal. Moving to our Lex Posh segment, the petitioner in this was himself a law graduate. In the inquiry, he wanted another law graduate to represent him, and he challenged Rule 7 of the Posh rules, which prevents a legal practitioner from assisting a party to the proceedings. The High Court held the rules to be valid. It recognized the fact that the Act does not provide for such a mechanism of a practicing lawyer being allowed. It is only to a limited inquiry. In fact, the procedure and process that the POSH Act itself provides for is different, and upheld the rule and said that the person, the respondent, who's the delinquent, and in the POSH inquiry is not entitled to legal assistance. Going back to a quiz question, the answer for this month's quiz. So if somebody is getting a supervisor, but still if his salary is less than 18,000, he would be a workman under the IR Code 2020. Last segment of this month is our complaints calendar, what would need to be done under the different enactments. This PPT would be circulated to all the participants, and you can take note of the complaints calendar. LexPosh, as part of CEOTSG and as well as with TS Gopalan being a knowledge partner, is doing a one-day workshop. Please do feel free to scan and register. Do participate. Our next program would be on 31st, the last day of the year at 4 p.m. Please do try to join us. Till then, stay safe. Thank you for joining today.